a decision in relation to which party has succeeded both on the law, but perhaps most importantly in relation to the competition. But I think it's fair to say on behalf of both of us that we found both of your submissions very compelling, very well presented, and we were very impressed.
Under the grounds that if the bank had applied for a court order, immediate court order would have been given on the grounds that Mr. Merchant could not pay these defaults in a reasonable manner. My lords, we're simply saying that our colleague's bank completely circumvented the law. It didn't go to court. It got repossessed, my lord. The house got repossessed. And also, my lord, according to Law of Property Act 1925, Section 103, which states that banks such as Prelog must at least give a notice before they can foreclose this home. Which, according to that, they're in violation of a statute. I hope that my colleagues today are not going to bring case after case after case that's going to prove that it's okay to be in violation of a statute. I hope that's not what we will see. My lord, my colleagues will also bring up that in Birmingham Citizens Permanent Society Building versus Count, which was the leading case in deciding Rupelage versus Barclays, the court has no jurisdiction to decline the order or to adjourn the hearing, whether on terms of keeping up payments or paying arrears. If the mortgagee cannot be persuaded to agree to this, my lord, my client was not persuaded, nor did this case go to court so that my client could show to the court, in regards to Section 36 of Administration of Justice Act, subsection 1 and subsection 2, that he could pay these arrears, he has been working hard, and he can make payments, so that the court could exercise subsection 2 and subsection part 1 and part 2 of subsection 2 of Administration of Justice Act. Now, my lords, it brings me to another case that I have to mention. And that case is of Hans and Merton. In that case, my lords, Hans and Merton took the counsel to court that by counsel's doing, Hans' argument was that it was becoming dangerous to her health. And Merton took the case to court, same counsel, same doings, that by the counsel's doing, he was losing value in the property. Under Public Health Act, my lord, Hans got justice, but Merton didn't, because it was meant to be a Public Health Act. It wasn't public, we will protect the value of your home act. Parliament's intentions, my lord, great intentions. In conclusion, my lord, I'd like to state that Administration of Justice Act has to be reinterpreted. We have to look at the Parliament's intention in regards to these mortgages for what we've seen in the past 5 years. We have to take away the self-help method that the banks continually apply and say that this section does not apply. This section does apply, my lord. And if this section doesn't apply, the reason on the first ground that we ask that the Rupelage case should be overruled is that it was decided in 1999, Human Rights Act. It was enacted in 2000. If we put, my lords, if we put Article 8 and Article 6 of Human Rights Act with the Administration of Justice Act, Section 36, we have to overrule the Rupelage case, because it would be inconsistent with the Article of Human Rights Act, Article 8 and Article 6. My colleagues will argue, my lords, that to reinterpret Section 36 of the Administration of Justice Act, it would bring an imbalance between the mortgagee and the mortgager. It would bring an imbalance to the mortgagee and the mortgager. My lord, we're asking the courts to rectify the balance of power and create a more equal equilibrium and correct the scale of justice. Correct the scale of justice. Taking into consideration these two things. Specifically, the intention of Parliament in Section 36 and Article 6 of Human Rights Act and Article 8 of Human Rights Act. Fair trial, my lord, fair trial. Thank you very much.
Thank you.
My line of opposition may have the audacity to stand here and tell you in a minute that Article 6 and Article 8 of the European Convention of Human Rights are limited rights, but from what I can see, the Article 6 and Article 8 of the European Convention of Human Rights cannot be limited in this case with reference to public policy or economic stability. If a layman out on the streets, a member of the public, knew that the bank could take away his house at any time, do you think that that man would be able to sleep at night? My learned opposition will cite case after case saying that yes, a bank doesn't need to wait until you're in default. A bank can take away your house as soon as the ink dries on the paper. But will this create a stable economy for this country? I put it to the court now that if this 16th century arbitrary self-help method is allowed to continue, it will create an atmosphere of fear and distrust amongst the people, and it would further threaten this already fragile economy. And it is for this reason in which, my lord, you must see that Rupert should be overruled because it did not take into account the European Convention of Human Rights. According to Section 36, which was later amended by Section 8 of the Administration of Justice Act 1973, for a court to suspend, postpone, or stop a court order, my client must prove that he is able to pay all sums due within a reasonable period. In order to determine that my client can pay off all sums due in a reasonable period, it must first be established what is meant by a reasonable period. The starting point for this is usually found in Cheltenham and Gloucester Building Society and Northern, in which Lord Justice Waite ruled, I am strongly in favour of adopting the full term of the mortgage as a starting point for calculating a reasonable period for payment of arrears. As you can see, my lords, the wording of Lord Justice Waite makes it quite evident that the life of the mortgage is merely a starting point for your lordships, and contrary to what my learned opposition may tell you, is by no means a finishing point. A reasonable period can be interpreted in two ways. The first and the most orthodox approach is to treat a mortgage as a trust. This can clearly be seen in Western Bank v. Schneidler, which was quoted and affirmed by His Honourable Lord Justice Waite in Northern. Lord Justice Berkeley clearly stated that in a suitable case, the period might even be the whole of the remaining prospective life of the mortgage. He then goes further in his obiter to say, I would not dissent from the view that if the courts could, if they thought reasonable to do so, grant an adjournment, suspension or postponement for an indefinite period. This unmistakably suggests that the courts can interpret a reasonable period of time which does extend beyond the current life of the mortgage. This leaves us now with the question of what is a suitable case. Berkeley J. made it obvious that this is solely dependent on the facts of the case and of the conduct of the parties involved. It is our submission that the appellant's case today can be considered a suitable case in which the courts can extend a payment which continues beyond the life of the current mortgage. If my lords take into account how the respondents have acted negligently when agreeing to a £240,000 mortgage on a house which is only worth £240,000, when it is clear to any competent professional that my client would not be able to keep up with these repayments, the bank was reckless and irresponsible and did not act in a bona fide way, in which my opposition will later tell you they did. But despite this, my client has managed to keep up with the repayments for 2 whole years before having forcefully led this country in order to find a better paid work. This is the first time the appellant has defaulted in 2 years, and almost instantly the bank repossesses his home without so much as a warning. According to Cheltenham and Gloucester Building Society v Grant, a first-time defaulter should be given help by the courts. They should be given help to draw up a realistic, variable financial plan, which includes how they are going to pay the arrears, how they're going to pay the interest, and how they're going to pay the principal sum. And there is no authority suggesting that this plan cannot extend past the life of the mortgage, because it has to be realistic and it has to be viable. This brings us on to the second approach that the courts could take in interpreting what is a reasonable period. What is a mortgage, but if not a contract between two people? This means that it is subject to the same laws of contract, and therefore can be varied and altered accordingly. It could therefore be argued that the financial plan approved by the courts could be a contract between these two parties and in effect vary the terms and conditions of the existing mortgage. This means that the courts can, in accordance with established principles of contract law, extend the life of the current mortgage in order to make sure my client can pay all sums due within a reasonable period, which is defined by both Lord Justice Waite and Lord Justice Buckley. If my lords are convinced that my client could pay off the sums due under a realistic financial plan, which can be drawn up by the court, then there is no reason to reasonably doubt that my client will breach this plan. Therefore, I ask you, my lords, today to consider that a reasonable period can extend beyond the life of the current mortgage. Further, it is our submission, which my senior counsel has already explained to the courts, that Rupert should be overruled in light of the new evidence of Parliament's intentions and the fact that there was no consideration for the European Convention of Human Rights, as the Human Rights Act came into existence after the case was decided. In my closing speech, I would like to leave you with this thought. England for many centuries now has prided itself on upholding the most fundamental principles of fairness, liberty, and above all justice, which burns ferociously in the hearts of every citizen, every individual in this country. But today, here now, we are here because the respondents decided that they could circumvent the law regarding Section 36 and take away my client's only defence. They decided that they could use a 16th century arbitrary self-help method in order to take away Mr. Merchant's home while he was working abroad, without so much as the sheer decency as to give him any notice, with the intention of trying to deny him any chance to defend himself. My learned friends will tell you that they could not give him a warning, that he was in another country, but there is not a shred of evidence to suggest that they've even attempted to warn him that his house was getting repossessed. They will quote case after case trying to make their point, but I ask you now, is this fair? Is this justice? Somehow, this draconic and sordid 16th century self-help method has endured through the decades, despite being in violation of both the Administration of Justice Act and the European Convention of Human Rights. But I am standing here today, my lord, in front of you now, in this great court, where great laws are created and established injustices are rectified. In this noble court, I ask you now to make history and correct a universally recognised wrong by giving Section 36 the meaning intended to it by Parliament, abolish the self-help method, and rekindle the fires of justice by guaranteeing that any and all mortgagees must obtain a court order before going to court. Thank you, my lords.